Everyone, Dustin here from lawatyourside.com, where we provide real legal help when you really need it. And are you wondering if you're going to win your workers' compensation case? Today I'll tell you what that really means and what the answer would be. So all the time at the beginning of a case, a client will ask me, hey, are we going to win the case? And in workers' compensation, usually it's not so much about winning a case, it's about how much value the case is, or what are your benefits going to be, or how much benefits you get. So for example, if somebody is injured at work and they reported the injury and they saw a workers' compensation doctor, at that point, we're not really about winning or losing the case. It's just a matter of what the disability amount is. The case is sort of won already, so to speak. So let me explain to you why and how that means. In workers' compensation, you generally have to prove three things. First is an employment relationship. So are you employed by the person that you got injured working for? Are they saying you're an independent contractor? Do they pay you cash or under the table and then you get hurt and then you make a claim? They say, no, we don't really know who you are. You never really worked for us. Those are all the first threshold issues of whether you are an employee or not an employee. So assuming you get past that, which most people do, and I'll talk later in a later video exactly how to get past that and what are some of the issues, but most people get past that. So assuming you got paid by paycheck, you got your W-2s, every year, there's not going to be any issue of employment. In California, there's actually a presumption that you're an employee that has to be rebutted. So assuming we get past all that, then we go to the second one, and this is the big one. This is what's called AOE-COE, arising out of employment or course of employment. So did you get injured? Is your injury because of your employment? Did it arise out of your employment, or did it happen while in the course of your employment? So for some people, this is very easy threshold to make. You're going along at work, you slip, you fall, you hurt yourself, and you go to the doctor. Done deal. You've proven that you have an injury that was arising out of employment or in the course of employment, so you have met that second threshold. Where issues occur, and this area, the second one is by far the most litigated area in workers' compensation. The second issue is, so it occurs for injuries such as cumulative trauma claims. So let's say you worked for a company for a year, 5 years, 10 years, and you did repetitive duties over time. You were lifting a lot, or you're cleaning, and you start to have pain in your shoulders, pain in your back, and you file a cumulative trauma claim. Most of the time, workers' comp insurance carriers will deny those claims. They'll say, no, we don't have any medical evidence that you had an injury arising out of or in the course of your employment. On denials, usually you don't need to worry about those in those kinds of cases. I talk about that in a different video, but that's the second threshold to meet. So if they do deny that, you would simply just go to a state doctor, and the state doctor would make a determination whether you had an injury arising out of or in the course of employment. Oftentimes, depending on what you're doing and how long you're working there and what the diagnostic shows, oftentimes they will find an injury. Not always, but oftentimes they will say you did have some sort of injury. Another hotly contested area is if you have something that's not necessarily tangible. So let's say you're working and you have a stroke at work or something like that, or you pass out while you're at work. The insurance companies may deny it because they may say, yeah, you were at work when it happened, but we don't agree that your work caused the stroke or your work caused you to pass out, something like that. So that would be, again, a medical determination, which you would go to a QME or an AME for to make that determination. The more hotly contested AOE-COE issues are usually on specific injuries. So if you say that you got hurt on a specific day, and sometimes you report it, and the employer says, okay, thank you for reporting this, here's the pink slip, you're now fired. So they don't say anything to their insurance carrier, and sometimes will commit fraud by, when the insurance carrier calls them, they'll say, no, this person never reported an injury, I don't know what they're talking about. At that point, it becomes a he said, she said situation. In those cases, of course, if you're reporting a specific injury and you get fired, you want to go to the doctor right away to help demonstrate that you actually had an injury, to prove that you had an injury. That's very, very important, because otherwise it's just he said, she said. They'll get all their employer witnesses and tell all the employees to come back and say that you never had an injury. And then it just becomes a big battle at trial in terms of who's more credible versus not. Now, there's several other defenses that they may use. For example, if there's a physical altercation, like a fight, if you were the initial aggressor, you're the one who started the fight, or you were the initial aggressor in the fight, they can use that as a defense and say, yeah, you may have got injured at work, but you're the one who started the fight, not the other person, so therefore that's a bar to the claim. It could be an AOE, COE defense. So there's other different ones as well, such as the business traveler rule, like if you're traveling for work and you get injured doing some sort of leisure activity, were you really working or not? There are really broad exceptions to those rules, and that's for a different video. But basically, that's the second threshold. Did you get injured arising out of or in the course of your employment? Third and final threshold is, what is your permanent disability? So this is also an issue that can be contested, not as heavily as number 2, but this is the third one. And this is what I think people really should focus on when they ask, am I going to win my case? If you satisfied the employment and you satisfied the second one, where you had an injury out of course of employment, then it's just a matter of what your disability is. And for that, usually we'll go to a state or neutral doctor, and they'll give their opinion, and then we determine what the disability is based on that opinion, based on the diagnostics, testing that you have. So in conclusion, are you going to win your workers' compensation case? Well, it depends on the facts of your case, but usually not so much about winning, it's about where on the scale of your disability is. So thank you so much for watching that video. If this video helps you, please click the like button below and subscribe to our channel. Also, if you want a free consultation or for us to help you on your workers' comp case, please give us a call at the number below, and we'll be more than happy to discuss it with you.